on it before we go to the floor with it. Because when it goes to the floor, we don't need to be doing amendments. We need to do something to clean this up now. As such, we've got our chair of county affairs, where this bill actually has been referred first. Many of you represent governmental entities, and we're glad to have Senator Hill here to discuss that. My first question is, all of you've got a copy of the bill, right? Don't worry about the language yet, but tell me whether we like the process that we're aiming at in there to start with. Clerks, tax assessors, like the process. Clerks, Crow don't care as long as his name's not in there with circuit. So Chantry, do we have Chantry here? I think you're Chantry, all right? Tax assessors, Yelkins? Okay, Miss Ray, land and title. Anybody else want to comment? Do we like this route we're going? Because if we don't like the route, then we need to change it now. So far we hear that we like the route we're going with it. Now, there is language that'll be changed. We have our attorney and our Senate staff here to work through that. Let's get in the middle of the bill. Who wants to be up first? Tell me your opinions and where we need, what you're concerned about. Land and title, you want to start? Okay. So right now, the process in here is a registry that would be indexed. Tax assessors, that's going to come back on you just a little bit to bring in some of the indexing instructions. Is that a path we want to go with the indexing, or do you want to do a book in the office? No preference? No preference? It's good. Yeah. Okay. So you have no objection to that. As far as indexing time periods, right now it's indexed in their registry at least once a year. I know there's going to be some concerns on that from some of your title people. So what is our medium? Are we looking at a 6 month? Are we looking at a quarterly? I believe the process, Ethan, you can chime in and tell me, but the process currently has a board of supervisors certified and then it going on the record. Is that right?
Board of supervisors continue to send the notice to the tax collector at least annually. And then the tax collector, as soon as they get the notice, has to notice under the tax sale provisions. So I think that's the registry where the PPIN comes in.
So that's the annual. Board of supervisors, you want to comment on that at all? No problem there. So y'all like annually, land and title. You don't like annually. Tell me your suggestion.
How does that?
6 months, I don't think you can do a monthly deal. I don't think you can do a real time. You could. Ideally, we all want real time at some point. But I don't know that we're going to be able to take that first step right now to go real time. So
real time in our area, but we're having notice is quarterly. Versus annually, if that is better. We're already having to do a 90 days. We're supposed to notice the assessor in 90 days.
okay.
Yes, I think the bill leaves the board of supervisors as notifying the tax collector that fees assessed under that 90 days after fees are due. But before notifying the tax collector, the board of supervisors has to give notice to the property owner.
So we have to get notice to the property owner, we have to pin over our parcel.
That's right.
So within that,
It's a quarterly.
we got to do this notice anyhow.
If it is quarterly workable. I just want to know from.
I think that's a lot better than anything.
Okay. The question I've got is the counties that are not on board yet. We have some great counties who have some great systems out there that are, as you say, real time, and some that may not be real time. This process, is it going to put the small counties that are not currently doing this in a bind to make it happen quarterly just yet? We have anybody that can speak on that? Any small counties? I have no problem doing it quarterly. Yes, sir.
I will pledge to get that information from somebody. Tax assessors to see if the quarterly will be up. I can get that done.
At the minimum, can we at least agree to do it every 6 months? At the minimum, and if we can get the language back from your counties, Mr. Yelton, we can look at doing it quarterly. What say the board on it? I mean, the membership on that? Are you good?
Quarterly, if it's workable with the county.
So we know we're gonna move that from annually to at least every 6 months, hopefully quarterly. All right. Now, we have a number of $500 before a sale could take place. Now, I do have a question as to our sale. For these generations, it would be a special assessment. That's the route we're going with this. What say you on that within that bill, the $500 and then a sale? Go ahead. Yes, sir.
I'd like for it to be 250 or something, but 500, but that's what 500 is. Fair, I understand the ways that work.
Yes, sir. Go ahead. And please come to the mic. Come on up to the mic with that. If you can discuss that a little further.
As I read it, within the 90 days, the Board of Supervisors sends notice to the landowner and the generator at that point. And is that when the clock starts ticking on? I understand that the clock starts ticking on the 3 years the 3 years and $500 at that point.
The language says receipt of the original delinquency notice.
So once we certify to the collector after that 90-day period that John Doe is delinquent, then the 3-year clock for the sale is ticking for that September when the $500 hits. The 3-year clock is ticking. Then September 1, when they have that information, it will go on the tax bill, which if John Doe owes $1,000 in property taxes and $500 in delinquent garbage bills, he'll owe $1,500, and he'll have to pay the $1,500 prior to the sale. Otherwise, it goes through the sale. But he has an opportunity to pay it through or the mortgage company has an opportunity to pay it through the regular tax collection process.
That's the current method. Ethan, you want to speak to that? Is that your understanding?
That's my understanding. I wasn't sure when the 3 years would begin running. Is that?
If we take it out 3 after the $500, and you're out 6 years, and that's a long time.
Right.
That's way too long. In my opinion, I think that's way too long to try to collect it at that point.
So is the language clear enough?
The accrued amount has to be over 500. Yeah.
Once it hits $500 and the
$500 and 3 years.
and the 3 years, it is not $500 and the 3 years starts. That's what I wanted to be sure. It's 5 that we start there and go forward, and we can. Again, if that's the collector's position, that's fine. Like I said, we'd like it less and less time. We'd like 250 in 2 years, but yeah. But
I think where that 3 years came from was any hesitancy at all to commence a tax sale or just garbage. I think there was some concerns among members of that. So that 3 years allows everyone to have notice on this registry, because there are a lot of people that like these garbage liens are just out there and they don't even know about them. So it gives them some time for it to get the registry and property owners to say, oh, I do this.
I understand.
The safe haven to the property owner.
I understand.
Senator Brandon's got a comment.
Well, really more of a question is. I'm looking through the bill with you, okay, as we're discussing it. One of you had mentioned that you would be okay with 2 years. Which one of you?
That was me, but I'm the clerk and not the
I
collector.
understand.
So that would be that's.
Well, I'll just confess was my initial thought, was maybe 2 years instead of 3, but I would kind of like to hear both sides of why you think the longer time, and then maybe why you think the shorter time and how that's more workable. Just because I'm considering that.
Just from my perspective, it's the same process, whether it's 2 years or 3 years. But if you did 2, it'd have to drop to like $250 because we won't hit $500. I don't think most counties would hit $500 in 2 years. It'd be more of a $250 issue in 2. But if it's more workable for the collectors, at 3, I don't have an issue with that. It was just But it was just less time on the books it took than it is.
Well-
And it's quicker to get it off if there are any real estate transactions.
I'm personally not in favor of lowering the amount. That's just me at this point, but I do want to know what's the average amount of the cost of the garbage collection annually in the counties? Does it vary?
It'll vary. In our area, it's around 15, 16. We're at 1250, about to go to 15 or 16. And I think most of the counties in our area are around 15, 16, maybe $17. So 3 years it will take us 3 years to hit $500.
Okay, well, that helps me in my analysis of what I think. I personally don't want to see it go below 500.
It will, the 2 years won't help us at all if it's 500. If it's 5, it stays there.
Okay.
Yes, ma'am, Madam Chair.
This may be a hard question to answer, but this is the elephant in the room question. My major concern is whether or not we have any entities that do garbage collection, and I'm not certain whether in each county that the county bills or if the waste company on contract bills, but my concern that immediately comes to mind is how many areas do we have that keep records like the water bills of the city of Jackson?
And that's a great question, and that leads us to our next one. One of the major answers that we wanted out of these meetings was to be sure that we didn't have liens recorded in boxes in a storage room that appeared now. So my question here is for the registry, Madam Chair, we were talking about at our previous meeting, having a certain time period in which this registry was to be created. And you were to file those if you were going to claim them as a lien on real property. And if you did not get them within that time period to start that registry, they would become personal. Now, do we have it in this bill to that level? That's the question.
It doesn't look like it, but I just glanced at it, but I would say also that potentially having it, how far that they could go back to begin putting them in the registry so that they couldn't collect from 10 years back. So if you initially start the registry, you know what I'm saying?
I agree.
So we need some parameters to where, how far can you go back billing? Is it gonna be 3 years to start, or where is it gonna be? Because if you're 3 years to start, you're automatically gonna be at that $500 level. So,
Line 115
okay.
on,
Everybody move to
So it's-
115. Let's
it
look at
says that
that.
fees have to be imposed after January 1st, 2018, which
Okay.
was 5 years back.
Oh, that's a long
And
time back.
then-
That's gonna trigger a tax sale
And then
to the
they have,
$500.
they have to do that.
That's not gonna give anybody any time. It doesn't sound like.
That's where that 3 year period, like if it did trigger, so some of those people would be immediately over 500. They'd go on the registry, but the tax sale couldn't commence until 3 years later. They'd have those 3 years to pay that amount off for the tax sale commence.
Everybody
So it's
got that? So
The fees have to be imposed after January 1st, 2018, and then the entity, the Board of Supervisors and tax collectors all have to comply with this section by September 1st, 2024. So if they can't get their things together, then that reach back.
And so on that first year, is there a time frame in the bill to where the landowner has to be notified after the debt has come in and been registered, or does it have to
Well,
go?
the
Have to go to the
section,
Board of Supervisors before it's put on the registry and the property owner has to be notified? Okay.
Board of Supervisors, before they can send the delinquency notice, has to notify the property owners. That's
Okay.
already
Okay.
law right now.
All right.
I don't know that all the counties are complying with that, but
he also did his best to make sure that we weren't putting unreasonable restrictions. Compliance has got to be within on or before September 1st, 2024 for that.
So
it's a year out.
So it's a year out. Are we?
Well, it would
counties.
be effective on July 1st, 2023, so they'd have like 18 months or something.
So what is the current process for notification, even on a tax lien, that we know for certain that somebody's been notified? I mean, we really can't, can we?
Jay Clark can speak to this, but I know you find it in your question for me, they send certified notice to the landowner.
Right.
Beginning of the tax sale, the collector has to run publication prior to the sale. Before maturity, once it goes through the sale, before maturity, the chancery clerk 6 months prior has to do title search, certified mail, notice, newspaper notice and sheriff's process before maturity, but not before the sale. It will be the notice from the supervisors, which starts the clock as I read this, and then the tax collector's responsibility would be to run the notice. Of course, they'll get their tax card that shows that I owe $1,500 instead of $1,000. That would have the assessment attached to it prior to January 1 of the year that you're able to put it on the tax bill. And then they would run publication prior to the sale in July. Late July, they have to run publication twice, late July before.
So is it gonna be incumbent upon the property owner, or if it's a rental property, upon the renter, or incumbent upon the board of supervisors, or the tax assessor to determine who was living in the house when the garbage was generated? Because that's what the bill says. But how are we gonna sort that out?
Fees actually under the section don't, it's my understanding, somebody can correct me, they don't run against the tenant of real property. So,
So it's only the property owner.
lines 21 and 22 and 23 continue to say fees for garbage and rubbish or disposal are assessed jointly and severally against the generator of the garbage or rubbish and against the owner. But for the key here is trying to clean up the lien for real property notice that we're giving the owners. And so it's still going to be jointly and severally liable here, but we're actually creating the true lien
So
process.
the owners better be collecting the garbage fee and the rent, basically.
Be the best thing they could do.
Yeah.
28 through, yeah, there's a little bit of an ambiguity in the current law because 28 through 31 also says any person who pays as a part of a rental or lease agreement an amount for garbage or rubbish services shall not be held liable upon the failure of the property owner to pay those fees. So really it falls on the property. It is assessed against both, but yeah.
But the collector does, as I read the bill, collector, we're taking away the holding of a car tag of the property owner. But the generator, should that be the renter, still comes in, car tag option is still there. And that could be collected before it ever gets to the property. So there is a method of collection from that generator if they're still in the county and still buying a car tag.
Yeah, and that's also a piece of the current law that's not being amended is during that 3-year period, they won't be getting their car tax.
The owner,
The owner and not issue or renew any by a person who is delinquent in the payment of fees. So it'd be the generator as well, but I don't know how the tax
apparently
assessors would
that's
know
not
that.
working.
Well, we're not trying to take away mechanisms from you. We're trying to give you an additional tool, and that's what we're trying to get through today. Yes, ma'am.
So under current law, if they withholding that tag, then no, how does the tax assessor know when they come to buy that tag? Is there any real data there for them to actually utilize?
Mr. Yelverton, you want to speak on that?
There is data that says there's a delinquency that's attached to that tag.
So they-
So
Have they been given
So
mailed
why
a
can't we
notice?
attach it to the, what would be the disadvantages to attaching it to the tag rather than the property? Because you already have a point of contact there that's in the code. I'm
It's-
just asking.
It's still out there as that mechanism. Everybody's going to use it because those 3 years, you still are accumulating more debt. I do think it's effective in some counties to hold tags. And it helps some, but it still doesn't, just for informational purposes, our state currently with the records that was pulled at my request from our counties have about $28.6 million in unpaid garbage fees across our state.
I'm not
So-
saying if we held the tag, I'm just exploring the possibility of what if we attach the lien and made them pay that when they got the tag rather than the 3-year tax sale? What if we attach the garbage lien to the price of the tag?
So you're just talking
Because
about
I'm-
an assessment.
It's, yes.
That is, and correct me if I'm wrong, that's current law and it would be required of them to do
So
that. It's
you're-
just some people aren't coming in for their tax. Basically.
So it would basically be a property owner out of state that you would be that wouldn't be coming in for
I
a
don't-
tag in the state of Mississippi or?
But under the language, they would still, they aren't allowed to issue the tax until.
That renters that maybe move on a
Yeah,
frequent basis,
yeah.
they'll move out of
Yeah,
state.
I'm talking about the property owner. So it typically, if the property owner was coming in to get a tag, it looks to me like that it would be collected unless they're an out-of-state resident. That's what I'm saying. It looks to me like you would be collecting this from the property owner because typically unless they're, 95 years old and don't drive, I mean, they would potentially be coming to get a tag, but I get it. There's a lot of people that own property that aren't Mississippi residents that aren't buying a tag here. So that,
I think I see an answer down there. It
And I
might
can
help
give you
us.
one answer.
Okay.
It is not unusual to have a property owner who knows they have delinquent garbage bills to use their daughter's address when they come in to register a car, or their mama or their daddy or whomever else. And so you miss, the addresses don't match because they don't own the.
and we need some way to, and it's totally different, but we need some way to match wherever they're buying a tag with their homestead exemption. Because that's happening for school attendance also. So that's another issue for y'all to figure out.
Let me take it one bite of this elephant at a time today. But there's one more area I do want to mention in here. I've already been hit up before the bill even got out. And before anybody in this room saw it, we're not forgiving debt.
Right.
I want to say that again, we're not forgiving debt. All we're doing is saying that if you don't put it on that registry within the time period that's assessed in that bill, it continues to be a personal lien. You can continue to use the car tag, hold that. You can continue to use your collection agents. You can continue to use any mechanism we've got out there except putting it on the indexed registry. Everybody got that? Now, where are our collections? Do we have Three Rivers here? We had Three Rivers here the last time.
I'm.
Yeah, that's right.
I don't work for Three Rivers.
You don't work for them, but you have an idea
I'm
what
on
they
the
might
Solid
like.
Waste Authority Board for them, so.
So my question here is, I don't want for this to get out on the floor. And we have collection companies coming after us saying that we're doing something to take away their mechanism. So tell me, do you see anything in here that's
I
gonna take
don't,
away?
and I provided the bill to them yesterday to look over and make sure that there was nothing that they have a problem with, and Three Rivers does not.
Okay. Anybody else in here got any questions or anything we need to look at? Because what I'd like to do is send this back down to Ethan. And remember, we've got to go to county affairs. I encourage you to be available when that meeting is here to answer these questions there. Anybody else? Mr. Chairman, do you have any questions you'd like to bring up? Senator Boyd, this was a big issue in your area. Do you have anything to bring up?
I do, and I appreciate everybody coming to the table, but please, I will ask everybody. This has been going on with. You've got issues, speak now or forever hold your peace. Because this kind of trickles in issues after issues, and let's hear them now. You've got issues because this needs to get through. We need to clear this up. It was time to do business. So speak now, forever hold your peace.
Senator Suber?
All right, I just, one question clarifying. So this registry, this is gonna be, we're gonna try to figure out a time frame. Right now, it's gonna be updated every year, but this is just for delinquent.
This will be a delinquent registry and it's going to be, we're going to attempt to do it quarterly.
The shorter period, the better, but, so right now, in my area, 90 days is showing delinquent and a lien is attached. So if we continue that, that's fine. I just want to make sure they're updated. The biggest problem I've run into, and I know Senator Boyd has the same issue, where I guess we're on the same collection company, but these lanes are showing up at just random times. I've checked title myself on my own property, came back in 6 months and there's a lien there from 5 years ago. So, is there gonna be a cutoff, or is there gonna be something that we need to get these all up to date? Anything prior to 2018.
2018 will continue to be a personal lien against the generator,
This cannot be used for part of the sale.
will not attach to the real property. So, yeah, I don't mind doing that, and I'm gonna ask all of you one more thing. If you had any other comments, requests for a review, if you don't mind, and Pat, I'm sorry for doing this to you, but if you wouldn't mind by 5 p.m. on Friday, get it, well, what time are you going home tomorrow? By 4 o'clock on Friday, get you, you can email it to her, you can drop it off here and she'll get it to us for us to go through. But 4 o'clock on Friday, because we want to get this moving as it is double preferred sometime next week. So 4 o'clock on Friday, any additional comments? Madam Chair, this is your bill to start with. Any further comments from you?
I think y'all have answered most of them. If I think of anything else, I'll let Pat know, but right now I can't.
Okay. As such, anybody else? Well, we'll have to rise and report because we've got a hearing here, but I appreciate you all coming in today and we're going to call this meeting adjourned.